A man charged with federal tax evasion says he's done nothing wrong because he's a Christian who refuses to give money to the government to support abortion. I don't believe I have broken any laws, as I have a duty and right to protect my conscience and to practice religion freely, Michael E. Bowman wrote in a declaration filed in court. A woman has the right to choose, but apparently the prosecutor feels I do not have a right to choose. Bowman's defense lawyer has urged the court to dismiss the case, arguing the government must make an accommodation for his client under the Religious Freedom Restoration Act. He wants to pay taxes, but until the government stops promoting the murder of babies with his income taxes, he cannot pay, his lawyer Matthew Schindler wrote in a motion to dismiss the case. The very moment, the instant that his money is no longer being used to promote murder, he will gladly pay every cent he owes to the government. While Bowman's abortion-related objection to paying taxes appears to be unique, the religious defense in tax evasion cases is not and hasn't been successful when used by others, legal experts say. This is a losing claim, said Lloyd Mayer, a tax law professor at Notre Dame Law School. Case law has held that the government's right to collect taxes trumps any religious objection or anti-war activists' objections to paying taxes to support national defense. The point of these laws is people don't get to pick and choose which laws they can agree to, said Kent S. Robinson, a retired federal prosecutor who served for 6 years as chief of the criminal division in the Oregon's U.S. Attorney's Office. It's one tax system that applies equally. Bowman's lawyer even cites the prevailing case law in his motion, but he argues that Bowman's objection to supporting taxpayer funding for abortion presents a different set of circumstances. In the 1982 U.S. Supreme Court ruling United States v. Lee, the court denied an Amish request to be exempted from Social Security taxes, which the Amish argued interfered with their free exercise of rights. Because the broad public interest in maintaining a sound tax system is of such a high order, religious belief in conflict with the payment of taxes affords no basis for resisting the tax, the court ruled. In a subsequent 2014 case, the nation's High Court in Burwell v. Hobby Lobby Stores Inc. ruled that requiring for-profit corporations to pay for insurance coverage for contraception under the Affordable Care Act violated the federal law protecting religious freedom. The federal law, the Religious Freedom Restoration Act, prohibits government from substantially burdening a person's religious exercise unless the government demonstrates a compelling governmental interest and does so through the least restrictive means. Although Bowman agrees the government clearly has a compelling interest to support Social Security in order to provide a safety net for elderly Americans or to support national defense through tax collection, the same compelling interest doesn't exist to support abortion, his attorney argues. Though federal law already prohibits government funding for abortion, except in cases of rape or incest, or to save a woman's life, Schindler cited a Congressional Budget Office estimate that the government paid $450 million in 2014-15 to Planned Parenthood, which performs abortions in addition to providing education, contraception, and other forms of reproductive health care.